All right, we are live, and I hope this is working and I'm not just talking to a blank screen. May 20th, the US Supreme Court has published a list of cases that they're denying and they're doing some orders on. And that brings us to why we are here right now, because the court has denied a key case and they have decided to not do anything on another one. Here's the overview of where we're going. We're going to be talking about one, the Maryland assault weapons case, as well as the magazine capacity case. I know, modern sporting rifles. I get it. Number two, we're going to be talking about Illinois, so-called assault weapon case and the magazine ban. And then number three, I'm going to try to prognosticate. I'm going to try to forecast for you all where I think this is going to be going in the long run with these sorts of firearm cases. I'm going to give you a little bit of history and evidence to try to back that up so that you can understand what the variables are when you're thinking about this, when you're discussing this with friends, and so forth. So I'm actually going to flip-flop the order. So let's first talk about Illinois. Illinois was the case brought by the National Association for Gun Rights. Fantastic organization. Check them out. I strongly encourage that you become a member. This one is the one that challenges all the crap that's been coming out of Illinois, Governor Pritzker, you name it, for over about the better part of the last year at this point. We've covered extensively on this channel. Basically, we're looking at almost a complete wipeout for modern sporting rifles, almost a complete wipeout for magazines. We're looking at how are magazines going to be treated under the law? Are they protected by the Second Amendment, or are they an accoutrement or an accessory and not an arm? And therefore, they can be regulated, they can be banned, they can be, you name it. That's effectively what's up on the chopping block on both of these cases, both Illinois as well as Maryland. And then, of course, we get back to the issue of, and we've covered it so many times before, I'm not going to belabor it in this video, but what's the proper test for determining when and how the government can ban certain firearms? And to be clear, I'm not suggesting that the government can do that. I'm just saying, here's what the US Supreme Court has basically thrown down as the gauntlet, as far as looking at common use, as far as looking at exceptions for dangerous and unusual. It's something I've actually done a lot of research on. We've got some videos coming up about the history about that goes back, over 700 years of looking at both American history, colonial history, as well as English common law history prior to that. So be sure to subscribe, check us out if you want to stay up to date on all of that. But the U.S. Supreme Court did not take any action. In other words, they did not accept or they have not denied. They've done nothing with respect to the Illinois firearms ban and magazine ban case. The good news to this is that it lives to fight another day. And of course, we have some U.S. Supreme Court decisions that might be coming out affecting the Second Amendment. We're looking at Rahimi and so forth, possibly later this week, this Thursday, which is going to be dealing with the question of who are the people in, of course, the Second Amendment, where we're talking about the right of the people to keep and bear arms shall not be infringed. If you're not part of the people, so the government's argument goes, then the Second Amendment does not protect you, and you can be banned from possessing weapons. You can be banned from all that kind of stuff. So big case coming down the pipes with Rahimi. That, of course, we'll be covering that as well. But maybe that's part of the reason why the U.S. Supreme Court decided not to take any action on the Illinois case. What they did take action on is the Maryland case. In Maryland, that's the case of Bianchi versus Brown, and more specifically, I think it's Dominic Bianchi et al. Versus Brown, Attorney General of Maryland et al. I've got some notes to kind of help me out here as I quickly threw this video together this morning to keep you all updated. The Maryland case we're talking about, there's basically an effective full ban on any kind of modern sporting rifle. And there's criteria that I'm going to be throwing in the description box below, so I don't have to go through it. But basically, if you've got certain features, you're done. If you have, we're talking folding stock, flash suppressors. If you got two or more of that, plus grenade launchers or flare launchers, I think. And then, of course, they also just banned 45 individual types of firearms just at the get-go, regardless of whatever features are on it or not on it. So we're looking at a complete wipeout, as well as we're talking about for magazine ban there, which goes back to the issue of, are magazines arms, accoutrements? Where are they? Because if they're an arm, then they're protected by the Second Amendment. Or if they're part of an arm, they're protected by the Second Amendment. If they're not an arm, if they're an accoutrement or accessory, well, then the government's theory is that therefore they can be banned, they can be chucked, they can be kicked, it's done. That's the argument here. What has happened is the U.S. Supreme Court has denied, and they've got very specific language. They said, quote, the petition for writ of certiorari before judgment is denied, end quote. That's from the U.S. Supreme Court website, hot off the press as of time of this video. The petition for writ of certiorari before judgment is denied. The most operative language there is before judgment, because what happened, broad strokes, low resolution, is the pro-Second Amendment side effectively lost in the Fourth Circuit Court of Appeals. That's the circuit that hears Maryland. And then post the Brune decision back in 2022, which of course completely reshaped the landscape, part of the Holy Trinity, along with Heller and McDonald, we're talking about Second Amendment cases easily, completely reshaped the legal standard, the legal atmosphere of how Second Amendment cases are to be litigated, thought about, written about, so forth. What are the thresholds and criteria that the government must satisfy to be allowed to, let's face it, infringe on our rights, right? So in light of that, there was a petition to the U.S. Supreme Court saying, hey, we kind of lost this back here in the Fourth Circuit. Can you do something about this? So the U.S. Supreme Court vacated the decision at the time. That's the Bianchi case, the Maryland case, vacated the decision. So they wiped it out, press reset, and then they sent it back down to the Fourth Circuit and said, guys, rehear this. Look what we wrote in Brune. We want you to apply this history and tradition test, or more specifically, when we're talking about weapons, actually less history and tradition. And really what we're talking about is, of course, common use and potential exceptions vis-a-vis dangerous and unusual. Again, not for today's video. Well, what happened is very, very strange. So these circuit courts, which are the federal courts of appeal that sits between the federal trial district courts as well as the U.S. Supreme Court, these circuit courts fall in between. They have these pools of judges, and when a case is accepted for hearing in one of these circuits, what they do is they basically poll a pool, a subset of these judges to hear these cases. And what had happened in this particular case, after the U.S. Supreme Court kicked it back down to the Fourth, is they wound up getting a wipeout. Again, I keep saying that, but it's true. They wound up getting a wipeout where the en banc court probably saw the written decision of what the smaller judge panel was going to do and said, no, guys, we're not going to do that. We realize you had oral arguments back in, I think it was December of 2022, but it's now January of 24. And we're just going to press the reset button. We're going to hear the whole case en banc, which means all the judges sitting together. Why would they do that? Well, I mean, this is speculation time, but they probably are doing that for the same reasons why they probably did that in another case before. That was the Maryland Shell Issue versus Moore case, which basically dealt with the fact that they didn't like the fact that the smaller judge panel was probably going to reach a pro-Second Amendment decision. So they reheard the whole case en banc, wiped out the decision. Second Amendment then loses, and that's probably where this is going. Enter our other friends. For this case, we're talking about the Firearms Policy Coalition, National Association for Gun Rights. That's the Illinois case. Firearms Policy Coalition, that's what we're talking about. Maryland, another fantastic group. Go check them out. Of course, there's also Gun Owners America, Second Amendment Foundation, so many others that deserve your support. So it's very easy to plug all those groups when they're fantastic. So at least we got that going for us. We may not be litigating this all on the pocketbook of Uncle Sam and using attorney generals to try to fight to pass gun control as our adversaries are, but we do have fantastic groups, and they can only be fantastic for us if we support them. So be sure to check them out after this video. So there's some history here about why they may have done what they did. And the Firearms Policy Coalition basically took the opportunity to do an appeal up to the U.S. Supreme Court and say, look, before this is heard en banc, guys, this is a very basic, straightforward issue. Over the last decade, nearly 20% of firearm sales are modern sporting rifles like the AR-15. They are absolutely in common use by the tens of millions of numbers here. Tens of millions. Magazines, we're now talking hundreds of millions. Hundreds of millions. That is not a typo. Hundreds of millions. these are common use weapons. If these aren't common use weapons, there's probably nothing as common use weapons. And keep in mind that the US Supreme Court, in the case called Catano with a C, something we've also, of course, covered on this channel before, basically ruled that less than 200,000 electronic weapons actually were considered safe grounds, safe harbor provision for being in ordinary use. So we've got a couple 100,000 electronic weapons that came out in Massachusetts, as I recall, as being good to go. We have now tens of millions. So the argument from the government is going to have to be that they're going to be dangerous and unusual. So where is this all going? Well, for starters, Bianchi's going to now wind up going back. So they're going to wind up hearing the case out in the Fourth Circuit. So we're going to hear it en banc. The Second Amendment will probably lose and will probably be back in the same position later on in 2024. That is, unless the Illinois case basically trumps that, because keep in mind, these Venn diagrams have most overlap here. There's not much daylight between these laws. Yeah, they're different, but there's a tremendous amount of overlap. So if the U.S. Supreme Court rules in the Illinois case, wipes out the law, that's probably good news for Maryland. So otherwise, depending on how things all shape out as far as timelines, we might have both these cases potentially combined. We'll see. But otherwise, bottom line, Illinois lives to fight another day. Maryland's going back to the Fourth Circuit for probably what would be a loss. So big picture, where's this all going? Because if you're like me, it's yeah, these battles are great. Tell me about the war. Okay. So the U.S. Supreme Court, we've got 9 judges. We need 5 in order to get a majority decision in order to basically create a precedent. It's more nuanced than that, but that's the gist to it. So in 2024, keeping in mind the magic number is 5. Here's what we've got for judges. We've got Thomas, we've got Alito, we've got Gorsuch, Kavanaugh, and Barrett, and Roberts. That's 6 that have been appointed by Republican presidents and will presumably be the judges that we need to rely on in order to protect our Second Amendment rights. To the left of them, we've got Justices Jackson, Kagan, and Sotomayor. So that's our 9. There's been 2 cases over the last 8 years or so. One was in 2015, which was another Illinois so-called assault weapons ban case, a magazine capacity case, i.e., of course, modern sporting rifles and normal capacity magazines. That was Freeman versus City of Highland Park. And this one actually had the writ for certiorari. That's the permission slip to have the U.S. Supreme Court hear your case, which, keep in mind, any given year, the U.S. Supreme Court can only hear give or take, between about 1.3% and about 3% of cases. So they just lack bandwidth, okay? And that is what it is. So that writ was denied back in 2015. Now, a couple important things about that. One was the fact that this was, of course, pre-Bruen decision. That's big. We now have an entirely different way of doing business, so to speak, when we're talking about the Second Amendment. 2 is the fact that, frankly, the court is different now in 2024 than it was back in 2015 or later on in 2017 when there was likewise another denial for a Second Amendment case. Back in 2015, on the hopefully pretty darn safe Pro 2A grounds, we had Scalia, Thomas, and Alito. That's kind of the right wing of the right side of the court, right? And then you kind of the center right, which at the times was largely Roberts and Kennedy. And then somewhere to the left of center, you had Justices Ginsburg, Breyer, Kagan, and Sotomayor. Okay. So that was a situation where we had a 5-4. And if I didn't mention it, of course, Scalia's out there on the right wing. So we had a 5-4. And we had 3 folks that were presumably going to be safe votes. Now we've got a 6-3, but there's also interesting new questions that arise in this because, of course, all of you guys are going to know, well, look, the left is no more a unified bloc as the right is. You have on the right a division between your, for instance, pro-police right versus your more libertarian right. And that's going to be very relevant when we're talking about cases exactly like this. On your traditional rights, we've got some new judges that have joined us. we've got 3 that were appointed under President Trump. We've got Gorsuch, we've got Barrett, we've got Kavanaugh. Gorsuch is a well-known libertarian right individual. Now, he would contrast nicely, for instance, with Justice Alito, who's a more of a traditional tilts in favor of police and prosecutors type. So that's kind of the distinction. A libertarian right judge or individual in general may prioritize rights as opposed to a more traditional one who might be prioritizing a lot of our institutional concerns. And that's not me editorializing. And I realize that's super low resolution, but for right now, that'll have to do it. So where does Barrett fit in on this? Because if you look at this, we've got 6-3, which means that the right side, if they are going to be the pro 2A, they can presumably give one person. That one person may be Roberts. So you can give one and still win 5-4, but you can't give 2 because then you lose. So I want to focus for a moment on Justice Barrett because unlike some of these other judges, she actually has a pretty lengthy voting history when it comes to Second Amendment topics. In 2019, before she was promoted to the U.S. Supreme Court in a case called Cantor v. Barr, this was a case that dealt with felon in possession of firearms. So we're talking about 18 U.S.C. 922 sub G sub 1. This case was one that she cited during her confirmation hearings as one of her most important cases that she had sat on to date. She wrote a 37-page decision dissenting from the majority who basically ruled in favor of the law that criminalized felons being in possession of firearms. So she dissented from this. And importantly, she went down this whole path of history and tradition and looking at the fact that, look, there is, in her view, and I'm not saying her view to mean it's not my view, just covering what's going on here, folks. In her view, there was no colonial or older law that goes back to the early Republic founding fathers when the Second Amendment was either proposed or adopted, 1789, 1791, that dealt with just banning felons from being in possession of firearms. Now, keep in mind, importantly at the time, there weren't nearly as many felonies back then, and those that existed were generally capital punishments. So you get into some of the nuance in this stuff, and it's, well, yeah, look, you're not going to find a lot of these laws that may have prohibited felons from being in possession of firearms because the felons were dead. But also keep in mind that a lot of the laws, we didn't see the radical expansion of criminalization and turning things into felonies until much later than that. But her whole point in looking at this lineage and traditional law was, look, there is such a thing as the colonial era folks prohibiting individuals who were dangerous from possessing weapons. But that's not the same thing as somebody who sits in a broad class as felons. There are many people who are felons who would not be physically dangerous to you if they caught you at a disadvantage on the side of the road, for instance, right? Also, she dealt with this virtuous citizens test, which is something that if you've been following this channel, you know that the government keeps citing time and time and time again. Virtuous citizens, virtuous citizens. Well, she got into that by basically saying, look, if you really want to split hairs here, virtuous citizens were the folks who could basically serve on juries and people who dealt with voting rights. So she basically classified those as being civic rights as opposed to individual rights. And she noted that individual rights, freedom of speech, freedom of religion, and so forth, there seems to be no record of those rights being expressly stripped from less than virtuous citizens. So all that's great. Here's the bottom line. If the right side of the court are the current protectors of the Second Amendment, and right now is probably going to be the high watermark of what we're going to see as far as a conservative U.S. Supreme Court, who presumably are going to be the protectors of the 2A, though we've covered how maybe that might move in the future. But for right now, that's absolutely the case. This is going to be the high watermark, most likely, of where we see a conservative court to be. We can give one. We've got 6. We need to hang on to the other 5 at this point. I don't know where this is going to go, but this absolutely seems like the right time to be rolling the dice. And I think that Barrett's going to be one of the safe ones looking at this. We'll see. We need to, of course, hang on to Alito. I feel good about Gorsuch. I feel great about Thomas. And Kavanaugh could be a little bit of a wild card as well. We'll see. And I've basically written off the left side of the court, at least when it comes to 2A issues in 2024. So we appreciate you sticking around. We're going to reward those of you who have by tuning in for our favorite quote of the day. This one comes from noted Roman speaker and thinker Seneca. Men can be divided into two groups, one that goes ahead and achieves something, and the one that comes after and criticizes. Hope you got something out of this. Don't forget, if you want me to be able to respond to your comments, for those of you typing during the live stream, you're going to have to post them up after this video goes live in like the normal YouTube sort of way. Again, thanks for bearing with me on the video. I realize it's not up to our normal kind of grade here for audio and video. Derek, our video producer, is at a major award festival for one of his indie films in Cannes, France. We wish him nothing but the very best. But in the meantime, you will be suffering with me in my office. I got my Second Amendment library here. That's partial library, I should say. I've got a lot more at home. And I look forward to seeing y'all later on this week. Take care.